Good afternoon, everyone. Welcome back from lunch. I will try my best to keep you awake during my presentation this afternoon. So my name is Janellys Santa. Like Danny said, I am the outreach coordinator and paralegal for the Ag Worker Rights Program at Legal Aid of Nebraska. I've had the pleasure to work with many of you already, and I am very happy to reconnect with all of you today. I have prepared this presentation in a way that can be easy to understand, since law are not always very easy to fully comprehend. So by the end of this presentation, we will be discussing 3 scenarios. They will be interactive because I want to make sure that nobody took a nap during my presentation. So today we will be discussing a very important law that will be coming into effect really soon. The current laws that we currently have that does protect our pregnant workers in the ag field. Now, the new law is called the Pregnant Workers Fairness Act. That's what we were going to be talking about today. And we're going to be briefly discussing the laws that are in effect right now, just because the new law is not into effect until later on this year. We want to make sure that we are also aware of the things that are in effect currently. So we have decided to present on this law since we have seen an increase in discrimination claims during pregnancy in the ag field. I thought that, since all of you work with this population, it would be nice for you to have another thing to present to the workers when you have interaction with them. If this is something that they're experiencing, that there are protections for these workers out there. And hopefully by the end of this presentation, you will have a good idea on how to guide these pregnant workers assert their rights and protect themselves and their pregnancy. Let's talk a little bit about legal aid if you're not familiar with what we do. We are the largest nonprofit law firm in Nebraska. We serve the 93 counties. We help any worker that is in need in all of the state. We do have 7 office locations in Omaha, Lincoln, Bancroft, Norfolk, Grand Island, North Platte, and Scottsbluff. We do have priority areas. We can help with almost everything except criminal and immigration cases. We can assist clients with their housing needs, such as eviction, foreclosures, unsafe housing conditions, utilities, shutoffs, and returns of deposits. We can also help with family cases such as domestic abuse, juvenile record sealing, divorces, custody, and child support. We have a division that helps with debt and finance matters such as bankruptcy, debt collection, wage and bank garnishments, student loans, debt, and medical debt. Lastly, we do have a division that helps with matters regarding income and benefits such as disability benefits, public assistance programs, unpaid wages, and unemployment benefits. Now, Danny and I work at the Ag Worker Right Program, and we're dedicated to help these workers with issues that are related to their employment. We help workers with wage theft, labor trafficking, unsafe housing, discrimination and harassment. Oftentimes, we do have casual conversations with these workers, and we find that there are many violations happening that they are not even aware of. Workers are not fully educated on their rights when they come to the United States from their country. And so they oftentimes run by what the employer says. They're basically at the mercy of the employer, and they usually do settle for what the employer demands. So that's why Danny and I dedicate time to visit and educate all of the ag workers so they know that they do have rights, and not only that they have rights, they also have a lot of resources and organizations that are ready to jump in and help. Having said that, I do want to thank every single person in this conference that has worked with us to give these workers the protections they deserve. Like I said, I've worked with many of you already. I've received referrals from many of you as well, and we are very grateful for that. All right, let's talk about the Pregnant Workers Fairness Act. All right. In 2021, the EEOC received 2,261 complaints of discrimination due to pregnancy. And these are only the cases that were reported to the EEOC. Imagine all of those that didn't make it to the EEOC. As you know, as you have probably interacted with these workers, many of them avoid reporting any unfair treatment just because they're afraid of not being invited to come back to work, basically being let go. It is sad, but I'm sure that there's more than 2,261 complaints that truly do exist, that are currently happening. One of the things that I found that I was surprised, but not really surprised, was that a survey conducted in February 2022 showed that 1 in 5 women experienced some sort of discrimination due to pregnancy in their workplace. And this is not only in the ag field, it's in general. In any workplace, 1 of 5 women have experienced some sort of discrimination due to pregnancy. All right, like I said in the beginning, in this presentation, we will be discussing the new Pregnant Worker Fairness Act that will come into effect soon. And this act came about after a constant discrimination against pregnant workers who needed accommodation to keep their jobs. Like you can see on those facts right there, it is very common. And I am sure that in this conference, there are women who identified with these facts stated here. I am one of those women. While doing the research for this presentation, I kept thinking about my own experience seeking a job while being pregnant. Granted, I was very much aware of the protections that existed at that time. You know, I wasn't born in the United States, right? However, when I came to the United States, I knew my rights. I knew that I couldn't be discriminated against just because I was pregnant. However, I also knew the huge stigma that being pregnant while in the workforce has. That gave me plenty of fear. And so I want to share a little bit of that story with you, because I know that many of you will relate. At that time, I was in desperate search for a job. I was very young and needed an income. I remember I did my interview fully aware that I was pregnant. I did not disclose that, of course. I was very, very early on in my pregnancy, so I know I could hold it. I could hold in the news for a while, at least until I was hired and out of those 3-month probation, the probation period. I was hired, and as many as you might know by now, the first 3 months of pregnancy are not very easy. And I hid all of those symptoms for as long as I could, with fear that they would find out and they will find an excuse and let me go. Time passed by and I started showing belly. So I knew, you know, I didn't have a lot of time before I actually had to report and say my condition. And so my direct supervisor was not very thrilled. I remember being very afraid when I saw my supervisor's reaction. And so I knew we were very short-staffed. That meant that maternity leave was also on the table. And so I knew I was, having all of this scenario in my mind. Okay, what is he thinking? He's probably thinking, oh my God, she's going to leave. We're going to have one less person. At that point, I felt obligated to reassure him, listen, I'm going to work until the very last day of my pregnancy. Regardless whether I feel good or I don't feel good, I will be here. I will make sure that I am here. I am trying to compensate, giving this news to him, and I'm trying to reassure him that even though I am pregnant, I am not going to be a burden to him, and I'm not going to be a burden to the employer. I'm trying to basically, make him feel better for giving him this type of news. I think about this, and it is very unfortunate that pregnant women has to fear for their future in that way. We are already worried about the multiple ways bringing a child will really change our lives, and adding that stress on top of that is just unfair. Can you imagine how a migrant ag worker would feel? Oftentimes they are very strict here in the farms. They have certain expectations. When they come here specifically to work in the farms, to just work in the ag field, they know that physical activity it's a big thing. It's something that they're going to have to face. It's something that they have to do, right? Many of these migrant workers come here because this is the way they feed their families back home. At this point, they're not thinking about the limitations a pregnancy can give, because they are willing to do anything. As I was at that time in my life, I was willing to do anything to keep that job. They would do the same thing, right? They are very hardworking people, and they will literally accept unfair treatment. They will accept unsafe, anything, just so they can feed their family. The farmers are not always very excited about workers that have limitations, and pregnancy oftentimes translates to limitations. As you go through the pregnancy, there are things that you will not be able to do as easy as you would during the first 3-4 months of the pregnancy. And so farmers are not necessarily thrilled about the idea of having a pregnant woman, because it's also a liability, right? They see you as a liability. So with this, I want to basically explain this new law that would hopefully change things, something that we can educate these workers and let them know, okay, this is an option that you've got. If you are facing any sort of pushback because you are needing an accommodation, this law concentrates specifically in the accommodation request. When there's a limitation due to pregnancy, a pregnant worker can request an accommodation and should not be retaliated against. All right, let's talk about the law itself. So this law will go into effect in June 27th of this year. And like I was saying, it will protect an employee and applicant by providing them with reasonable accommodations. The covered employer will be required to provide reasonable accommodation to a worker's known limitation related to pregnancy, childbirth, or related medical condition, unless the accommodation will cause the employer an undue hardship. Who is a covered employer? An employer is, a covered employer is someone that is in private and public sectors who has at least 15 employees. Congress, federal agencies, employment agencies, and labor organizations. Now, when we talk about known limitations, and this is here in the second paragraph where it says, the covered employer will be required to provide reasonable accommodations to a worker's known limitations. The employee needs to communicate the limitation and mention that it is due to pregnancy. Quick note, miscarriage is also considered under this act. So any medical condition that is related to a miscarriage, any procedures that are done due to miscarriage, and the recovery time that happens after that, it's considered under this act as well. So if you do need a reasonable accommodation after experiencing a miscarriage, know that you are protected under this law as well. All right, let's talk about requesting a reasonable accommodation. Here are the things that we should do when we're going to be requesting accommodation. After making your limitation known, you need to make sure that you are, when you're doing this request, you are correlating this request, and you're going to say this is due to my pregnancy, or this is due to my condition after miscarriage. You want to make sure that the employer knows why you have that limitation, so they know that you are covered under this new act, right? A written request is not mandatory, but it is very encouraged. If you're going to have any type of request or any communication with your employer about your limitation and about the accommodations that you are needing, make sure that you have it in writing. You will keep track of all of this communication. If there's any misunderstanding later on, or if there's any pushback that happens, you have some sort of track and some sort of proof that you have done what you needed to do in order to assert your right under this new law. So I put here 3 examples on how to request these accommodations. First one is, I am needing frequent bathroom breaks due to my pregnancy. So here I am telling you exactly what I need, and I'm telling you why I need it. You don't have to go in depth. You don't have to explain why. You don't have to necessarily just, tell them a story why, right? You just have to let them know this is my need and this is why I have this need, right? Second one, due to my pregnancy, I have swollen feet and standing for long periods of time hurt my feet. Again, pretty easy. I'm telling you what I need and I'm telling you why. Third one, due to my gestational diabetes, I need to eat multiple times a day. Again, pretty easy. We're not going into details. I'm just telling you what I need and why I need it. All right, examples of reasonable accommodations. We're talking about ability to sit or drink water, receive closer parking spots, have flexible hours, receive appropriate size uniform and safety apparel, receive additional break time to use bathroom, eat and rest, take leave or time off to recover from childbirth and be excused from strenuous activities and or activities that involve exposure to compounds not safe for pregnancy. These are reasonable accommodations in general workforce. So any pregnant worker that is needing a reasonable accommodation in any type of work, these are some examples of what you can request. Reasonable accommodations at agriculture. These are the most common accommodation requests we see at the farms and meat packing plants. Reminder, meat packing plant workers are also ag workers. In farm settings, it is common for workers to have more opportunities to have water breaks, so this part should not be a problem. The ability to perform less strenuous activities can be somewhat tricky, as they are usually in movement, bending, lifting, scooping, kneeling, walking, such. One of the main things to think about when we're going to request accommodations is thinking about multiple ways of completing a task. Not the way that the task is normally done or the way your employer trains people to do this task. We need to kind of like think out of the box. Okay, how can I get my job done even if I need to modify the task? Oftentimes in this type of field, not only your job will be modified, but the team's work will be modified as well. And this is a reasonable accommodation. This is something that the employer should be able to do to accommodate you and your needs. The worker must have appropriate size uniform and safety apparel. They should not have to wear anything too tight. And again, the farmers should already allow workers to have plenty of breaks to use bathrooms and rest, especially during the hot temperatures. But this specific accommodation is a common problem in the meatpacking plants. And one thing that I want to get out there is that regardless of the line speed and the presence of employees that are in the line, a worker who requests this accommodation due to pregnancy should receive the opportunity to take breaks for bathrooms as often as needed. A worker should never feel harassed for utilizing this accommodation. And I say this because I've heard multiple times women that have requested to have more break time to go to the bathroom, specifically in the meatpacking plants, that co-workers have an issue with that. Many of them feel that it is unfair for some reason. Even though they're fully aware that, you know, the worker is pregnant, it's just not, for some reason, people have issues with that. And so the workers should not feel harassed by anybody, not the employer, not the employees, nobody. You are asserting your right. You have the right for reasonable accommodation, and a reasonable accommodation is extra break, bathroom breaks, period. Nobody needs to interfere in that. Now let's talk about prohibitions under the PWFA. First, an employee should not accept an accommodation without a discussion about the accommodation between the worker and the employer. This means that, let's say you tell your employer that you're pregnant, but you don't say anything else. You say, hey, I'm pregnant, I'm taking maternity leave and this date. And the employer take it up on themselves and they give you an accommodation. You have not requested none of it, but they give it to you. That should not happen. You should not accept anything that the employer gives you just because. You have to have a conversation with your employer and let them know your limitation. Like we talked in the beginning, these conversations have to happen so they understand you have limitations, and that's why you're requesting reasonable accommodation. You don't accept things that you don't request. Second, an employer is prohibited to deny a job or other employment opportunities to a qualified employee or applicant based on the person's need for reasonable accommodation. This really applies for the people that apply for jobs. I've seen cases in which people have applied for a job and they are given an offer. And then when they give an offer, the employee communicates the accommodations that she's going to need in order to perform the job. They let them know why they need this accommodation, and suddenly they withdraw that offer with some other reasons. That is a prohibition. You would be covered under the PWFA if that does happen to you, just because you requested reasonable accommodations. Third, an employer is prohibited from requiring an employee to take leave if another reasonable accommodation can be provided that would let the employee keep working. So basically, this is telling you, if you request a reasonable accommodation so you don't have to stop working, the employer needs to abide by that. If you can be moved into a different position that doesn't put your pregnancy at risk, the employer should do that as well. It is a prohibition for them to say no and just leave it at that. We don't have an option for you, and let you go. That's just straight discrimination. Fourth, an employer is prohibited from retaliating against an individual for reporting or opposing unlawful discrimination under the PWFA, or participating in a PWFA proceeding, such as an investigation. As in anything, like the other laws that protect employees, retaliation is a prohibition almost in everything, and it is under the PWFA as well. If you have reported that you need special accommodation and you are retaliated against, that is a prohibition. You are covered under the PWFA. If you have reported this discrimination under the PWFA, you are retaliated against, again, still covered under the PWFA. Lastly, an employer is prohibited from interfering with any individual's right under the PWFA. Basically telling you the employer needs to abide by your request. Now, when we're talking about employers abiding by your request, the employees don't have first choice. Let's say you have requested to be sitting down to complete your task. You don't get to choose what type of chair you get. You don't get to let them know what type of chair, what brand of chair, none of that, right? Your limitation says that you have to sit down. The employer can provide you with a chair. That's that. You don't get to choose. And that's unfortunately something that the employer can get away with. All right, let's talk about other protections against discrimination. We're going to talk about this a little bit just because I want you to be aware of the things that are currently out there to protect you from discrimination. They're not the same thing as the PWFA. However, they do protect you against discrimination. So, a reminder, as we were talking about the PWFA concentrates only on the accommodation side of the pregnancy. And so when you request a change, when you request anything that would make your job easier, that you don't have to stop working, that would fall under the PWFA. The next laws that we will be talking about does not concentrate on reasonable accommodation. For instance, Title VII. It does protect an employee from discrimination based on pregnancy, childbirth, or related medical conditions. It does require covered employers to treat a worker affected by pregnancy, childbirth, or related medical conditions the same as other workers similar in the ability or inability to work. Then we've got the American with Disabilities Act, also known as ADA. It protects an employee from discrimination based on disability, requires a covered employer to provide reasonable accommodation to a person with disability if the reasonable accommodation will not cause an undue hardship to the employer. It uses basically the same language as the PWFA. However, pregnancy is not a disability under the ADA. There are conditions that are related to pregnancy that could fall under that disability. It cannot be a permanent disability. If it's due to pregnancy, it's more than likely temporary, right? So you would be covered under the ADA if that is the case. So there's pregnancy-related impairments that are disability if they substantially limit one or more major life activities. And when we talk about major life activities, we're talking about walking, standing, lifting, and major bodily functions. And so if you're experiencing any issues that does not let you walk, stand, lift, or just major bodily functions, then you would be covered under the ADA. Like I said, pregnancy is not a disability. However, if your conditions are making it an impairment in such way, ADA would be the law that protects you. Now let's talk about family medical leave, also known as FMLA. It does provide an employee a job protected leave for a certain, give me a second, it disappeared. Oops. There we go. It provides an employee a job protected leave for certain family and medical reasons. The employee is able to take 12 weeks of unpaid time off without the risk of losing their job. And lastly, the PUMP Act. It does require an employer to provide reasonable break time for an employee to express breast milk for their nursing child for 1 year after the child's birth, each time such employee has the need to express milk. If you see, there's not a specific time or a specific times where the person can actually go and express breast milk. It tells you as the employee needs. Something to keep in mind. Sometimes employers do want to put a limit on the times that you are away. And so this is something that we want to make sure that it's clear. It is as many times as the employee needs. The employees are entitled to have a place to pump at work other than a bathroom that is shielded from view and free from intrusion from coworkers and the public. All right, let's talk about hypotheticals. I've got three hypotheticals coming up, and they do have questions, so please show me that you were not napping and interact with me. Let's talk about Sally. Sally has been working for a small local farmer. She is a permanent resident of the US and has been for 2 years. Her duties include the harvesting corn, cleaning of the corn, and driving the workers' bus to their assigned houses. She has multiple duties since the farmer has just 10 employees, including her. She's pregnant and recently diagnosed with preeclampsia, which is high blood pressure, and she's being treated for it. She was directed to have less physical activity at work. The question is, does Sally have the right to request reasonable accommodations and why? Can anybody tell me? Can Sally request reasonable accommodations? Yes or no? And why? Denny, can you see the chat? Because I can't.
I can. We have a little bit of division. We have someone that says yes. We have someone that says no. We have another that says yes. So we got a few yeses, a couple, a no, another yes.
Wonderful. Okay.
People seem pretty confident that it's yes.
All right. Well, Sally is not an employee of a covered employer since the farmer only has 10 employees. Remember, we talked about people are covered under the PWFA if they are an employee of a covered employer. And a covered employer is someone that has 15 employees or more. So Sally has been working for this farmer that has only 10 employees, including her. Unfortunately, she cannot be covered under the PWFA for reasonable accommodations. However, if she is discriminated against due to her limitations, she could have claims under Title VII and ADA. All right, let's talk about Andrea. All right, Andrea is currently working at a meatpacking plant, and her duties include cutting and processing meat. The line speed is usually quite fast, and the need of keeping up is a priority. She is pregnant and notified the employer about her need for often bathroom breaks. Her employer informed her that due to her current need of workers in the line, she no longer can work there since leaving her on the line could affect her pregnancy and they do not want to be liable. She has requested to be moved to another department that is less strenuous, and the employer told her there are no other job positions available, and so Andrea was let go. What can Andrea claim and under which law? What do you guys think? I will need you again, Danny.
We have someone saying it is in fact discrimination. Give people just a few minutes to chat their answers here. We do have some more people saying discrimination.
Do we know which law she could fall under?
We got someone saying PWA.
It is indeed discrimination. And she could have claims under Title VII, ADA, and the PWFA. So she's got 3 options. All right, let's talk about our last hypothetical, and she is Michelle. Michelle is currently employed at a dairy. She recently suffered from a miscarriage and had a procedure which required a recovery period and less strenuous activity. She is also suffering from depression. So she has requested the employer to be moved to another department within the dairy where she could sit. Her accommodation was granted. She also requested more time for breaks to have time by herself. And so the employer denied her the break times and reminded her that she does have 2 15-minute break allowed per shift. Can Michelle request more break times if she was moved to a less strenuous job as she requested already? What do you guys think? Can she request break times, more break times? Can she justify that?
We got someone saying no, we got a yes. Somebody says not without a doctor's note. Got another yes.
So Michelle can also request more break times, even though she already requested to be moved to a less strenuous job. She got that accommodation. She can still request extra break times because her reasoning to request these break times are for mental health purposes. And like we discussed previously, mental health is also a condition that is covered under the PWFA, and not only the PWFA, but it's also covered under the ADA. So if Michelle goes to the employer and says, listen, also I am needing additional break times. I'm suffering from depression after my miscarriage. I would like to have more breaks so I can be away from, the noise or whatever the reason. Just kind of correlate that to the miscarriage, right? And let them know this is why I need it. It is a reasonable accommodation. And this is something that the employer should be able to do for Michelle. Again, it goes back to how we are requesting these reasonable accommodations. We need to make sure that we are saying the right things. We're stating why we are needing it. We're letting them know it is due to my pregnancy, due to my miscarriage. So we are covered under the current law, the ADA, and then the PWFA. So again, the way we are requesting things plays a lot into, what we're going to get later on. But yeah, Michelle can actually request it and should be able to get more break times.
Hey, Janelle,
All right.
sorry. Oh, sorry. I have a quick question.
Go ahead. Yeah.
And I know you did already mention that it's like the way that we are asking, but so she would get that reasonable accommodation for her depression just because it's correlated to her miscarriage, which is under the PWFA.
Mm-hmm. Yep.
So she couldn't
That is right.
She couldn't request it under just ADA and say she wasn't pregnant, she just had depression.
ADA would be if for discrimination purposes. Jenny,
Okay.
Let me know if you agree on that. But it is ADA would be for discrimination. PWFA concentrates specifically for the accommodation. If the employer says no to the accommodation, then she has a claim under the PWFA. If she is discriminated against because she has depression due to her miscarriage, ADA would be the law that she would fall under.
Okay, but it has to be due to her miscarriage, so you wouldn't
For
get
the PWFA,
accommodations.
yes.
Okay, thank you.
Yeah, no problem.
I'll jump in there. I know we got about 3 or 4 minutes, so I'll try to speak quick. Diana, just to answer your question a little bit, I'm certainly not an expert on the ADA, but historically speaking, the ADA hasn't recognized things like depression, generally speaking. What makes the PWFA a little bit interesting here is that it's including a lot of those, some of those mental health issues that result from pregnancy. Now, I will state, and I think Janellys mentioned this earlier in the presentation, the PWFA doesn't take effect until June. This is a new law, and it's very much modeled off of a lot of what we have, whether that be the language in the ADA. We actually do have another law called the Pregnancy Discrimination Act. And so we actually don't know exactly what is going to be litigated yet, right? We don't know how all of that's going to shake out. I will say one other thing here. In terms of the practical effects of a law like this, you got to think about how is this going to be implemented? How does it affect the people that we're serving right now? Because I can go to my employer and tell them blue in the face and tell them this is the law, you need to respect it. And they could just tell me to pound sand, right? And I could lose my job, or I could have some sort of negative effect. So, you know, to think, how is an employee going to enforce this? Now, when we're dealing with certain employment, let's take discrimination, for instance. One of the remedies that we use most often is we help clients file with the Nebraska Equal Opportunities Commission, the NEOC. The NEOC is tasked with enforcing basically Nebraska's version of the Fair Employment Practice Act that prohibits discrimination. Now, again, there's different things that you have to take into account, like the employer size, what exactly the discrimination was, and whether they're a covered employee. There's a lot of factors into that. But what makes employment law so difficult is that you have this giant Venn diagram of different laws that will sometimes overlap, that sometimes don't, right? We have laws that have a 15 employer size limit. We have the FMLA, which is 50. We have just these intersecting laws that you got to try to figure out, and that includes state laws and federal laws, and you got to figure out when and where they apply. So from a practical matter, and getting an employer to comply with this stuff isn't always easy. And so I lost my train of thought just a little bit, so I apologize. But I was actually going to ask, Janellys, if you could move back one or two slides on scenario 2 with, forget this was, yeah. Here we go. So real quickly, you know, one of the things they teach you, or one of the sayings that they have in law school is this notion of the brick makes the wall, right? You have one brick, and those bricks, if you put them together in a certain fashion, can eventually make a wall. The brick in a legal case will be one certain fact, right? So you have a bunch of different facts that eventually make your case, this brick wall. Obviously these are just exercises, but there's a lot of facts just even in this scenario that we don't know, which not necessarily listed how many employers this meatpacking plant has. We're going to assume it's large because meatpacking plants tend to be large, but the size of the employer is going to be important. One of the other big things that happens, or the big facts in discrimination cases, are similarly situated employees. And I think that's going to likely be what the PWFA is going to be looking at as well, is in comparison, what are these reasonable accommodations going to look like? And also one thing that we do point here, and Janellys did point this out, it's not unlimited. There's provisions in there that said if it's it can't be an undue burden to the employer. You can't force an employer to build a whole new section to their factory just to comply with the act. So there are limitations to it.
Anybody has any other questions that we can address?
I have a quick question. This is Jennifer from Proteus, and I think I put it in the chat, but since you can't see it, I'll just let you know. So for the accommodation, does a woman have to tell her medical condition, or can they just state a medical condition? So I don't know if I want people to. So you have to state your medical condition if you're a diabetic, or if you have depression, you have to tell them that.
Janellys, I can go ahead and answer that real quickly since we're
okay.
Yeah, Jen, it's generally speaking, yeah, you got to think also if you're an employer, you can't just take the word of your employee to say, I have this condition, now you have to comply with my accommodation. So the employer is entitled to some sort of proof that you are in fact going to. So if an employer were to ask for for some sort of medical confirmation, yeah, I think they would be entirely within their rights to do that. One thing you can put, and I know Diana pointed this out too, postpartum depression is going to be an interesting new frontier for this PWFA, I think, because like I said, historically speaking, mental health issues have not been something that's been allowed to be claimed for ADA or for most of anything else, right? If you're going to apply for disability or Social Security, or that they're starting to now to get to that point where they're recognizing the debilitating effects of that. What's the most important thing is for the purpose of the PWFA, you have to be able to relate it back to your pregnancy. And so if you can, you would have to likely, and this is again just speculating here because we haven't had a chance to litigate this quite yet, you would likely have to prove that you did not have that depression prior to your pregnancy, and that the whatever mental health issue that you had was in fact a result of your pregnancy. Again, devil's advocate here, if I'm an employer, if I'm an attorney for an employer, I may try to attack that, right? To say, let me show you, it wasn't the pregnancy that did it, it was this, that, or the other thing, right? So pregnant employees should probably know that going in, that there's probably going to be some level of proof that they're going to have to show. So, okay. If you think of any other questions, go ahead and throw them in the chat. We'll try to respond to them if we can. We do want to get back on track here, and we're scheduled for another break real quickly. So Janellys, thank you for that wonderful presentation.
Sure.
Thank you everybody for your attention. We're going to take a break here till the top of the hour.